Good afternoon, everybody. My name is Jane McAdam, and I'm a Scientia Professor of Law and the Director of the Evacuations Research Hub at the Kaldor Centre for International Refugee Law. I would like to acknowledge the traditional owners of the lands on which we meet today and pay my respects to elders past and present. I'm delighted to welcome you to this speed briefing on our new Kaldor Centre policy brief entitled Ensuring Protection in Humanitarian Emergencies, a Framework for Australia. The purpose of this policy brief is to recommend a framework for humanitarian emergencies that would enable the Australian government to provide a streamlined, equitable, predictable, and effective response to assist people caught up in crises. Recent conflicts in Afghanistan, Ukraine, Sudan, and Gaza have seen large numbers of people unable to leave dangerous situations. And sadly, these situations will not be the last. In each case, Australia's humanitarian response has been different. For some groups, acquiring a visa to escape and travel to Australia has been relatively easy, whereas for others, it's been nigh on impossible. Varying visa entitlements also mean that even among those who do manage to escape, some people have work rights, health entitlements, and access to a wide range of services, while others are barely surviving. And what we found was that over time, at least 25 different visas have been used to respond to humanitarian emergencies. It doesn't have to be this complicated. A centrepiece of our policy brief is the visa regime. Simply because if you have a visa or you don't have a visa, it could really be the difference between life and death. But our proposed emergency framework is far broader than visas alone. As we set out in recommendation 1, we make 8 recommendations, the emergency framework would provide a ready-made plan that could be activated if the Australian government declared the existence of a humanitarian emergency necessitating a protection response. This would be a contrast from defaulting to ad hoc and hastily devised policies. The idea is that the framework would encompass both physical and legal mechanisms to facilitate people's safe and swift departure. It would set up clear lines of authority, processes for consultation across different levels of government and with relevant stakeholders, identified reception facilities for evacuees if physical evacuation is necessary, and there would also be a visa with appropriate supports and pathways to durable solutions, including for affected individuals who are already in Australia when a humanitarian emergency is declared. Recommendation 2 focuses on the need for consultation and planning. It explains why, to be effective, the framework would need multi-sectoral engagement and coordination, including to facilitate arrivals and ensure that people are properly supported. It should engage stakeholders from all levels of government, from relevant international agencies, from refugee protection and settlement services, and from other relevant agencies and experts, including refugee-led organisations and the Australian Refugee Advisory Panel, and also representatives from affected communities. The framework should include a mechanism to bring these stakeholders together if its activation is being considered, to ensure that responses are tailored to the situation at hand. The mechanism should be triggered as early as possible, and certainly once a humanitarian emergency has been declared. While existing frameworks such as the Federal Australian Government Crisis Management Framework and state-based DIS plans may be instructive here, none of these on its own provides an adequate template for present purposes. In recommendation 3, which is about resources and funding, we explained that the emergency framework should include a DIS plan-like mechanism, and a DIS plan is basically a domestic plan that's activated in a disaster context. It's a state-based plan. So we think there needs to be a mechanism like this for the initial response within Australia in order to cut across bureaucratic red tape and swiftly mobilise resources. This would expedite access to funds without having to go through separate procurement processes. and it would also encourage a collaborative cross-sectoral approach. Recommendation 4 says that as part of the framework, the Australian government should ensure that people are granted an emergency visa to facilitate entry into and protection within Australia if a humanitarian emergency is declared. The visa should automatically permit an initial stay of at least 12 months in order to provide immediate relief, as well as time to assess conditions back in the country of origin. Importantly, there should be a pathway to permanent stay if it's not safe, possible, or otherwise desirable for people to return home. As I mentioned, to date, Australia has used at least 25 different types of visas in humanitarian emergency responses. This has resulted in diverse outcomes for people who've been affected, as well as significant distress within diaspora communities in Australia concerned for the safety and welfare of family and friends stuck abroad. One of the problems with existing visas is that even those designed for emergencies can sometimes be too slow to provide urgent protection. In particular, they're not well suited to emergency responses for groups of people, that is, beyond a small number of individuals in immediate danger. Other visas are issued on a wholly discretionary basis. People have to be invited to apply for them, and they're not allowed to transition onto a more permanent visa unless the minister expressly permits them to do so. Now, while the use of different visas has given the Australian government some flexibility, it has also led to ad hoc and inconsistent approaches. It's also added to the challenges and inefficiencies within the visa processing system. We argue that the emergency visa should provide immediate access to services including Medicare and Centrelink, as well as work and study rights. As a procedural mechanism, a special humanitarian intake should be created for humanitarian emergencies to enable additional visas to be granted above the committed annual number in the refugee and humanitarian program. In terms of eligibility for a visa, we say that this should be determined on the basis of sound and defensible principles, using past Australian and comparative practices as a guide. Classes of people could be identified as potentially eligible for humanitarian emergency visas, and intersectional approaches should be central to identifying and assisting people through this framework. Relatives and diaspora communities within Australia could also help to identify people with a connection to Australia already, whether that be because they're family members, past residents, or people with links to Australian companies or organisations. And here, the Australian government should identify locally engaged employees, that is, those who've worked for Australian government, the Australian government or companies in the affected country where the emergency is. This recommendation aligns with past Australian practices of clearly designating particular cohorts for protection. And an example is Australia's former Special Assistance category, which was in existence from 1991 through to 2000. Furthermore, anyone who is in Australia at the time when their country of origin is affected by a humanitarian emergency and whose visa is due to expire should be granted an automatic visa extension or a bridging visa with the same conditions. And this shouldn't adversely affect their ability to apply for a different visa, including a protection visa. An emergency visa should allow people at risk to travel to Australia quickly and safely. That is why recommendation 5 of the brief says that the framework should include plans for physical evacuation from affected countries, as well as from countries where people might have sought temporary safety. Now, each type of evacuation will require a different set of considerations, negotiations, whether they be with host governments, UNHCR and so on, and other contingencies. Immigration requirements should be kept to a bare minimum, things like identity and security and health checks, in order to facilitate swift movement out of dangerous and often traumatising situations. Here, recommendation 6 focuses on reception facilities and support. In order to move people to safety quickly, If necessary, evacuees, if an evacuation is necessary, of course, they could be housed for a short initial period in temporary accommodation facilities in Australia, things like quarantine facilities that were used for COVID or army barracks. And what we also say is that this would be a way of moving people quickly and enabling them to go through health, biometric and security checks here if they haven't been possible before departure. People should also be connected with support services to assist with housing, physical and mental health care, education, employment, language and cultural support. And if people are housed in temporary facilities, then they should be assisted to move into communities within Australia as soon as possible. We also recognise that host communities might require additional support, and this too needs to be part of the framework's planning. Recommendation 7 emphasises the importance of durable solutions. As already explained, if people can't return home at the end of a 12-month period, then they must be given a pathway to permanent residence in Australia. We want to emphasise here that not everyone who has a permanent residence pathway will necessarily choose to remain in Australia forever. However, giving people the opportunity to do so provides them both with legal and psychological security. It can help to facilitate social integration and economic integration as well. And in doing so, it might encourage people to take steps to get their qualifications recognised and seek jobs commensurate with their skills, benefiting both themselves and the Australian community in the process. Finally, recommendation 8 of the framework says that the framework should be reviewed annually to ensure that it remains current and appropriate. After any activation of the framework, a systematic review and independent evaluation should take place, and processes should be adjusted in line with any recommendations that are made. So to conclude this overview, we argue that a purpose-built emergency framework would provide an equitable and robust foundation to enable agile responses that can be quickly tailored to specific conditions. This would not only benefit recipients of protection and assistance, but it would also assist the Australian government, which would have a template at its fingertips, rather than scrambling to find solutions each time an emergency breaks out. Australia has the opportunity to envision a bold, dynamic and forward-looking framework to protect people in humanitarian emergencies, building upon good practices from our own past and from other countries. This would signal Australia's clear commitment to international solidarity and responsibility sharing, and would show how states can respond to humanitarian emergencies in a timely, well-considered and compassionate manner. I would now like to invite my co-author, Dr Regina Jefferies, who is a postdoctoral fellow at the Kaldor Centre's Evacuations Research Hub, to join us in order to help respond to questions that you may have or comments that you might raise. And turning to you, Regina, I'd like to invite you to take the floor and respond to any questions or comments that have been raised.
Thanks very much, Jane. So the first question that's come up is actually, I think, a good way to kick this off. And the question is about numbers with respect to each emergency and whether the government should set a cap on numbers. And the thought in terms of the recommendations that we set out in this brief is that there will necessarily be some limit to the number of people who can be assisted through this mechanism. And the idea is that if the government can adopt a special humanitarian intake, they would be able to make that judgment in terms of numbers based on the individual circumstances, the character of the emergency at that time. And of course, that could be adjusted should things change. But the idea is that, yes, there would be some sort of cap, certainly, but that cap wouldn't necessarily be driven by necessarily where the crisis is taking place. It's more about the character of the humanitarian emergency. And Jane, I don't know if you had anything to add to that.
No, Regina, I think you've answered that question very comprehensively. Thank you.
Great. So the second question that we have, someone from Aotearoa, thank you for sending this in, and they are curious about whether there is a particular part of the Australian government that we think might be best to declare the humanitarian emergency. Jane, do you want to take this one?
Sure, thank you for the question. I mean, as we say, there's the broader consultation process requires a range of different actors. But in terms of the humanitarian emergency, we set out a way that, various definitions that are used in other contexts and how we think that that could be incorporated into the Australian context. I mean, I think DFAT, the Department of Foreign Affairs and Trade, is an obvious actor here. But we wouldn't say exclusively it must be DFAT. No doubt this would occur in consultation with, well, not least Prime Minister and Cabinet, but others within the government as well. And as I say, in terms of what that might look like, the policy brief goes into detail about when such an emergency could be declared. And I'd note here too that it's not just envisaged for situations of conflict. It could also apply to disasters, for example. And in the United States, that is a situation where sometimes special protection is extended. Likewise, in the European Union, temporary protection directive, although only ever activated for Ukraine, in theory also contemplates extending protection to people in disasters as well.
Thank you, Jane. The next question is whether such mechanisms already exist in any other countries and whether any comparative experience informs our thinking. I think I'll kick this off, Jane, and you may have more to say on the European framework. So there are other mechanisms that do exist in other countries. In particular, earlier versions of the brief that included some of these comparative pieces, but it became a bit too long. And so one of those is in the United States, there is a mechanism called temporary protected status, and it actually is available for quite a wide range of different circumstances, which may include natural disasters or conflict situations, and actually even a broader range than that. The specific visa entitlements, though, are actually somewhat narrower. Certainly, they don't include the types of support mechanisms once people are within the country that are recommended here that would provide people with the support that they need in order to live safely and securely. However, that is one sort of comparative example that we looked at. And then Jane had mentioned the European Union as well. And Jane, would you like to fill that in a bit more?
Yes, I mean, I think within Europe, the temporary protection directive does require a decision in order to activate it. So, for instance, it wasn't used in the case of people fleeing Syria, even though that was a very obvious example when I think many people looked on and wondered why it hadn't been. But certainly some of the structure there and the very fact you have a mechanism in place when there are potentially large numbers of people affected is a useful one to think about. We also looked at examples that might not immediately spring to mind. So, for example, Argentina has created a new kind of policy for disasters whereby working with UNHCR, people can be identified not only when they've fled a country because of a disaster, but where they're in a country where they are being severely impacted by disasters or climate change, and can actually be taken out of that country, if you like, and to receive protection elsewhere. And I think that's an interesting thing to think about here, where we are considering the need for evacuations in some cases. And there's a lot of practice, not always good practice, to do with evacuations, whether we look back to what happened in Afghanistan, which was clearly not a template that we would want to replicate, notwithstanding the fact that lots of people were rescued. And I think the flexibility of the response there, notwithstanding it was extremely chaotic, just trying to move people that could be assisted and not adhering to extremely stringent guidance is an important thing to think about. But also, if we go back to the Kosovo situation, emergency transit facilities that UNHCR, or that have been set up in other countries for people that UNHCR is identifying as in need of evacuation. There are all sorts of practices, past and present, that we can look to here as well. So as Regina said, we reflect some of this in the brief. A lot of it, there just wasn't the space to put there. Maybe I can just jump down to a question about how the emergency framework would interact with the regular humanitarian intake. Would it be entirely separate, or would it be part of that? I think that's been one of the challenges with responses to date, that sometimes people that are assisted from emergencies are then, the visas then eat into the annual cap that Australia has set for the refugee and humanitarian program. And what we are saying is that really this is a situation that warrants a special humanitarian intake, that is a number of places above and beyond that quota. Of course, the quota is an Australian creation. There is absolutely nothing in international law that says you can only have X number of refugees or other humanitarian entrants per year. And, you know, if you situate the vast need within the broader context of international responsibility and responsibility sharing and solidarity, then we would say, as has happened in past practice, not only here, but in other countries, these are situations where you need to have an additional intake. And the other reason for that, it's not just about humanitarian imperatives, but I think too, if you look within the diaspora community within Australia, for example, if people feel that others they know from their home country who are in need are being displaced because of this emergency somewhere else, that can set up tensions within communities within Australia. So the idea should be that that this is a stepping up above and beyond.
Jim, the next question was whether we'd considered how community supporter groups, so groups of 5 to 10 volunteers or more than 10 volunteers, might be useful in this type of emergency humanitarian framework.
Yes, I mean, oh, sorry, did you want to respond?
No, go ahead.
I was just going to say, I think certainly when it comes to assistance on the ground, support, absolutely. I think in terms of who would be involved in the more formal discussions about, well, what should this particular response look like? How do we tailor it to the context? There we would see community representatives from the affected group, and in time, people who themselves have come here to say, well, what are the needs of the community at the present time, as well as refugee-led organisations and the other various stakeholders I mentioned. Regina, I'm not sure if you want to add anything to that.
I would just add that, one thing that was interesting that just came out of the Senate report on Ukraine, it did actually deal with that exact question, because there were so many people within Australia who wanted to help and become involved. And so one of the ideas that came out of that was to have essentially someone coordinating and facilitating essentially between community groups and the whole of government. So perhaps this is something a little bit outside of the recommendations that we made, but certainly could be envisioned within a comprehensive framework. So the next question was whether we'd proposed a mechanism to require the government to make the relevant declaration when an emergency occurs, and what might that look like?
And I think it links into the question after that, which is on what basis should the Australian government decide when something constitutes a humanitarian emergency? Would we rely on the UN to make that call, or would the government do it itself? I'm happy to respond, but Regina, I'd also like to see if you would like to jump in first.
I think it is, I mean, it's an excellent question. I think that in the current framework, in terms of the disaster plan, there's obviously a role for DFAT in that. One of the issues is how sort of transparent that is. And so one of the ideas behind this framework is to make that mechanism more transparent, to make it something where you would need to meet certain criteria in order to trigger it, so that the response mechanism could be more equitable. And I would imagine that it would probably fall to a department like the Department of Home Affairs, perhaps in consultation with other departments as well. I know, for example, in the US, it is the Secretary of Homeland Security who makes the declaration for temporary protected status, but that may or may not be the right solution in an Australian context.
And I think too, this is where, no, certainly we can't, the UN can't tell Australia, now you've got to act, we're pulling the trigger and off you go. But certainly statements by the UN and UN agencies would be relevant. For example, United Nations High Commissioner for Refugees and their assessment of a particular situation. But I think too, this is where there is a discretionary element in terms of what is, I mean, when I say it's discretionary, no one can force the hand of the government, but that's where it's up to the government to say, we recognise this is a situation that warrants a particular response, and we provide guidance in terms of the brief as to what sorts of things you would look at to make that declaration. And, no doubt there would be a lot of advocacy from the broader community in terms of, here is a situation that really needs to be addressed at this time. But the idea is that once it's declared, the template or the framework rolls out. So it's then, okay, this is what we need to do. These are the people we need to bring around the table. These are the considerations. We need state governments involved. We might need, the federal government, obviously, talking directly to groups. And it's only in this way that you will understand comprehensively, what the particular needs of a community in such an emergency are, and the best ways to respond. And perhaps I can just at the same time go to this last question that I can see about whether unaccompanied minors would be eligible for the visa, and if so, how they would be supported in their settlement. Yes, I mean, we're not prescriptive in any way about who, we want to set up these broad principles for a visa, not say it's these 5 categories and that's it. Absolutely, unaccompanied minors would be eligible, and I think we have, then we look at how do we ensure that those young people are supported, are given the, have their particular needs addressed, are not put in more vulnerable situations, and have educational and other, all those other sorts of needs met that may be different from adults, for example, who are moving here. And we've got long-standing practice in broader policy that we can use here to assist, hopefully the best practices to assist children who are unaccompanied. Regina, I'm not sure if there's anything that you want to add to that.
No, that was everything, and I think we're right at time.
Indeed, we are. So I would like to thank you, Regina, for your assistance in responding to the excellent questions and comments that have been raised by the audience today. And importantly, thank all of you for joining us for this speed briefing on the Kaldor Centre's new policy brief. Thank you, and enjoy the rest of your afternoon.